Hello, everyone, and welcome to another PMC Shares workshop. I'm going to walk you through a little bit of what we are and what we do, and before I introduce our speaker tonight. Pennsylvanians for Modern Courts is a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is assured impartiality, accessibility, and respect. And our co-host tonight is the Allegheny County Law Library, which has partnered with us on this entire series. If you are watching remotely or in attendance and give us your email address, you'll receive these slides, so no need to take notes. PMC works to educate all Pennsylvanians about the courts and how to navigate them, as well as all legal topics. We've been around for 36 years. I know our banner says 35, but that is a year out of date. We have been working to create greater trust in the judiciary, as well as to advocate for reforms, among them merit selection. We have a number of other workshops coming up, a lot of them in this end of the state as well. Here are a few. We'll be back here on September 17th, but we've also got a cool event at Pitt Greensburg on the 15th. And of course, I would be remiss not to tell you that we have a QR code that you can scan to give us feedback. And if you do, it helps us apply for grant funding to do more workshops. So please take a moment if you are so inclined. And I'll introduce our speaker tonight. Our speaker, Carol Sikov Gross, is one of approximately 525 certified elder law attorneys in the country. She is the managing partner in the Pittsburgh law firm of Sikov & Love and received all of her degrees from the University of Pittsburgh. She also teaches at the Osher Lifelong Learning Institute at CMU and at Pitt. So I will hand over the presentation now, and you can take us away.
Ceremonial passing of the microphone. Thank you. Okay. All right. Put this on for 1 sec so I don't lose it. Thank you. Okay. All right. So I'm Carol Sikov Gross, and we're here to talk about estate planning because it's very important to be prepared for life's eventualities. Unfortunately, we're all going to die at some point, but we want to plan for that. We also want to plan, though, for disability or incapacity, because for most people, that is something that may happen before they pass away. And so that's why it's important to be prepared. And so we're going to talk about estate planning and some of the important documents that you can prepare when you're talking about an estate plan. So you would be talking, we're first going to start talking about a last will and testament. This is a document that goes into effect after you've passed away. So you won't be around to see what happens. That will be up to the people you have named in the will. We're going to talk about powers of attorney. And a power of attorney is a document where you, as the principal, authorize someone to handle certain things on your behalf. That could be financial matters. It could be medical decision-making. It could be something for a very limited purpose. And we're going to talk about these things as we move ahead. And we're also going to mention what's called a mental health care declaration and power of attorney. And this is to help someone make mental health care decisions for you if you become unable to do so for yourself. We're going to talk about a living will. And that's not really a will, but it's really an advance directive for health care, but it expresses your wishes for medical care that you would or would not want in the event that you had an end-stage medical condition. And we're going to also mention a HIPAA authorization, typo on that slide, Health Insurance Portability and Accountability Act. And we're going to talk about that authorization to get medical information. Okay. We'll now make this go forward. Okay. So the important part with doing any kind of estate plan is that communication is key. Why? Well, you can prepare a fantastic plan, but if nobody knows that you have it, if nobody knows how to find it, if something happens to you, it's not going to do anybody any good. So you want to plan ahead while you're able to make these decisions for yourself, because if you don't plan ahead and make the decisions, you're letting either state law decide, you're letting a judge decide, you're letting potentially a family member who you never really liked them, and suddenly they're the person making these decisions for you. So better for you to make the decisions for yourself while you have the ability to do so. Oops. Nope. Oh, I got to push the magic button. There we go. Let's see. Nope. Got it to work once. Okay. So normally, if you were going to talk to someone about an estate plan, you would start with talking about a last will and testament. And as we all know, this is a document where you express who you would want to receive your property if you were to pass away. How do you want them to get it? Do you want them to get it outright? Do you want it to go in some kind of a trust, which is a protected way so that they're not in charge of their own money? And you would also name somebody to be in charge of your affairs if you're gone. And this would be your executor. And in older documents, an executrix, that's a woman. You don't, okay. So this is the person that's going to step into your shoes after you're gone, and they're going to fulfill the requirements for handling your estate. They're going to collect your assets. They're going to see about paying your debts, paying income taxes, inheritance taxes in Pennsylvania, and then eventually making distribution to the beneficiaries who you've named in your will. So this is a very important document, and it contains a lot of different provisions. Okay, go forward. Okay, not quite ready to go there yet. All right, so basically, in Pennsylvania, you can do what's called a holographic will, which means a document that you handwrite. And so if I were here, I could handwrite, if I had a pen in my hand, I could take this blank sheet of paper and I could write a will saying, I leave all of my assets to anybody who's watching this class tonight, either in person or online. And if I signed it at the end thereof, at the bottom of the page, and dated it, that could be a valid will in Pennsylvania. So if you went into the Register of Wills office here in Allegheny County, they have wills done all different kinds of ways. Somebody did a will, they carved it on a desktop, and that desk is actually in the basement at the city county building. Somebody else wrote their will on a roll of toilet paper. They guess they were sitting there a long time, had nothing else to do, and they unrolled it, and that's where their will is. I would not suggest that. It's not the best way to do things, but it might work as a last will and testament. You're better off if you do it. You know, it's always good to have legal advice to make sure that you're doing it appropriately so that what you want to have happen after you're gone actually happens. In Pennsylvania, if you don't have a will, that is called dying intestate because you do not have a testamentary document, a last will and testament. So the law in Pennsylvania says, okay, if you die without a will and you're married and it's a first marriage and you have 2 children with your spouse, the spouse gets the first $30,000 of your estate. The rest of your assets are divided half to your children and half to your spouse. And you may say, well, that sounds okay. I'd like that. But, you know, if your children are minors, if your children are not good at handling money, you might not want them to get those funds. If it's a second marriage situation, it's a little different. Your wife gets half, your second wife, and your kids from your first marriage, they get the other half. Well, maybe that's not what you wanted to do, but that's what the law says. So in a will, you can specify, I want everything to go to my wife, and if my wife predeceases me, then everything would be split equally by my children. And if they're minors, we might want to put a trust in there, and we'll talk about that in a little bit. Okay, now, people say, well, Carol, are there other ways that property can pass? I don't have a will, but I do have some other things that I've done. And yes, it can pass outside of your last will and testament, and there's a couple of different ways you do that. One of those is by joint ownership. If you and your spouse have a joint bank account, on the death of the first spouse, that whole account belongs to the surviving spouse. You can set up a joint bank account with your children. You could set up a joint bank account with your niece or your nephew. I could set up a joint bank account with Nina. We could have a nice account. And then whoever dies first, the money all goes to that surviving joint owner. Okay? So there are some problems with doing that, because what if the plan is, you know, I put my children on that account with me so that if I pass away first, they'll inherit that money. But if one of them, God forbid, dies first, I might actually end up having to pay inheritance taxes on part of my own money because I am viewed as inheriting it from them. And my other children are also part of that, and they would have to pay inheritance taxes on what they've inherited. So it's a good thing to talk about and make sure that you want a joint account and what it would do, you know, because if it's a joint account, my kids could go to the bank while I'm alive and take money out of it. That was not my intention, but they could. So this is where we use something else called a transfer on death or a payable on death bank account. So it's my money. I can do anything I want with it while I'm alive. But when I die, it's going to be payable on death to my children. So they have no lifetime ownership interest in it. If one of them passes away with that designation being on my account, I don't have to pay inheritance taxes on my own money. It's a nice way that doesn't give them access to those funds. So if I spend every penny before I die, oh, so sad, too bad, they don't get anything, but it's my money and I should be having control of it. You'll often see a transfer on death or payable on death clauses on savings bonds, sometimes on investment accounts, but it is a way to pass property that is not included in your will. You can also do it by beneficiary designation. So for example, with life insurance usually has beneficiaries. Retirement accounts would have beneficiaries. You could put beneficiaries on an investment account. And the will does not control that. It's controlled by the beneficiary designation with the life insurance company. And if you want to change the beneficiary, you can't do it with your will. You have to do it with the life insurance company and change the beneficiary designation with them. But it can be very useful. So if a person says, well, I have a joint bank account with my daughter, I have life insurance that names my children as the beneficiaries, and I have a payable on death brokerage account, they might not need a will. Now, if they have a house, if they have a car, if they have other personal property, they probably will need a will to deal with those type of assets. But again, it's just going to depend on what people have and what would make the best sense for their estate plan. Now, I tell people when we're going through this process and we're talking about end-of-life decisions, in addition to talking about a will and property that's passing outside of the will, we also want to do some other things. So we might want to pre-plan and prepay for a funeral. Why? It makes it much easier for your family to deal with things after you're gone. They don't have to make those very important decisions while they're grieving. And it's one of the things that you've now made simpler for them. All they have to do is call the funeral home and it's all set. I talked to a lady earlier this week. She said she's already written her obituary. Again, another thing that will make it easier for her children when she passes away, because they will know what she wanted to tell about herself in the paper. I thought that was really smart. It's a good thing to put together a list of your assets and probably your debts as well, because you know what you own. Nobody else may know that. So you might want to list, your real estate. I have a bank account at Citizens Bank. I have a CD at Dollar Bank. I have a small brokerage account with Charles Schwab, whatever it might be, so that the executor of your will know where to look for these things. We have an estate right now where we don't know where any of the accounts were. We know the decedent must have had one, but we don't have any idea where. So suddenly we'd have to write to all the banks in the city to say, did so-and-so maintain an account with you? Wouldn't it have been nice if this person had left a list of where their accounts were? Also, same thing with your life insurance, any annuity policies, retirement accounts. All of these things make it easier for the executor to do their job. And also I wrote down on here about passwords and security question answers. Why? Well, you would want your executor potentially to be able to access your computer, to get onto your iPhone or your Android or whatever kind of cell phone you have, because maybe there's pictures on there that they would want, or maybe there's financial information because, oh, by the way, you do all your banking online. So there's no bank statements that are going to show up to give them a clue about stuff. And if they don't have your password and they don't have your security questions answers, like where did you go to grade school or first grade, and my favorite, my homeroom teacher in high school, or whatever my favorite football team. That's an easy one. Everybody should know the answer to that. But the whole idea, well, that's because we're here in Pittsburgh, but the idea is that you want to have that information not near your computer, not where somebody could find it easily, but you would put these things with your will and your powers of attorney and things like that, so that the person who you ask to help you would be easily able to get hold of these things. Okay. One difference, if you don't have a will and you die, and the intestate law in Pennsylvania is what's going to control how your property passes, you don't have an executor, you have an administrator, and state law says who that would be. So first of all, it would be a spouse, then it would be adult children, then it would be the people entitled to the residue or the balance of your estate. So it's pretty specific, and it may or may not be the people that you would want to have in charge, which is why it's nice to have a will, and you can name your own executor. Okay, now, all right. So now we've talked about kind of what happens after you die and how you can plan ahead for that in a variety of ways. But most of us, before we die, will have something happen. Either we'll get ill, we'll become incapacitated, maybe we'll have macular degeneration, where we have our marbles, but we can't see to do the paperwork, and we need some help to have somebody do that. Okay? So that's where we do powers of attorney. And this name, you name someone that will act on your behalf. You're known as the principal, and they're known as the agent or the attorney in fact, and you authorize them to act on your behalf. Power of attorney is only effective while you're alive, because when you're authorizing someone, if you're dead, you can't authorize anybody to do anything, okay? Now, there's different kinds of powers of attorney, and we're going to talk about each of them. Financial, healthcare, a limited power of attorney, and a mental health care power of attorney. The most important thing, though, in doing a power of attorney is deciding who you're going to name as your agent. It needs to be somebody that you trust, somebody that will do things the way you would want them to be done, make the decisions according to what you've told them you want. And so that's why it's really important that it's a person that you trust. People say to me, well, I'm thinking I might name my nephew, but I'm not sure if he would do a good job, and he's got some problems. And I'm like saying, well, then you don't probably want to name him. All right. So you don't have to name a family member. You might decide to name a friend of yours, thinking that they might do a better job. The important thing with these powers of attorney is that they are in writing, they are signed, and financial powers of attorney particularly have to be notarized and have 2 witnesses. The purpose of this is so that the bank or financial institution or a real estate person, they will rely on these documents, and they have to be signed with appropriate formality, so that there's things that you have to sign, and we're going to go through that. Now, people say to me all the time, well, how many agents do you need? Well, let's assume you only have one child, you trust them, they're wonderful, you can name them, but what if the 2 of you are in a car one day and you're both injured and a meteor falls on the car, and you might want to have a backup? I always tell people you want to have a backup executor, you want to have a backup agent, because you just never know. If you name somebody that you spend a lot of time with, if something happens to you both together, who's going to step up? Okay, so should there be a backup? Yes, I think so. If you really don't have anybody, you can let it go, but normally you'll put a power in the power of attorney that permits the agent to name a second person. If they know, like, the agent is ill, they're dying, and they might decide to name another person because somebody's going to have to step up for you. And people always ask about naming multiple agents. So I had read a power of attorney recently, and the person named all 4 of their children. Well, that's great, but the problem is then you have 4 people who have to make decisions together, they have to sign things together, and they may not always agree. So I think that can be a problem. Usually you want to name 1 person, maybe 2 at the most, and you can name backups, to say, okay, if the first 2 children can't do it, then I name the other 2 children, but I really wouldn't suggest naming all 4 of them together. It just makes it very difficult and unwieldy to use. Okay. Sometimes I get it right and sometimes I don't. Okay. So let's talk about a general financial power of attorney, because this is where you're authorizing the agent to handle financial matters for you, whether it's to pay bills, whether it's to make deposits in the bank, whether it's to deal with your real estate or your insurance and investment account, maybe to hire a CPA to do your taxes, sue on your behalf. Now, this is a power here. The next one is something that's a newer power. It's only been in effect the last several years, accessing and using digital assets like computers and cell phones and things like that. Well, again, they can't access those things or use them without having your password and or your answers to security questions. So this is another reason we want to write these things down and leave them with your estate planning documents. You can give the agent powers to do things such as change or add beneficiary designations. You can give the agent the authority to make gifts of your property. But if you do that, again, that would affect your estate plan if the agent changes and adds beneficiary designations, if the agent gifts a lot of money away. So you want to make sure that's a discussion, to have with somebody who can help you make the appropriate decisions for your own situation. Because they can work and they are very useful powers, but you don't necessarily want to give them to everybody. Okay. All right. Got it. Okay. But a general durable power of attorney is something that will go into effect, and it is good from the time it is signed until it is either revoked or you die. But sometimes people need to do what are called limited powers of attorney. A limited power of attorney gives an agent the authority to do some very specific tasks. Generally, there's a short time frame, and these may be like, all right, I'm going on a cruise for 6 months. I won't be around to pay my bills. So, I'm going to give you authority to write my bills from January 1st to June 30th, okay, at my PNC bank. That could be very specific. It might be participating in a real estate closing. I made plans to buy this house, but now they've scheduled the closing and I'm going to be out of the country on this cruise. So you can go to the closing and sign the deed and things like that. Or sometimes this works for people with small children, is to make medical decisions for minors. Because again, I'm going to be gone for 6 months and the kids are going to stay with you too, by the way. I forgot to tell you that. But in case any of them fall and break their arm while I'm gone or need a shot, or you have authority to do that. So these are very specific powers of attorney that are only good for a limited duration and only for certain very specific tasks. But they can be very helpful under those circumstances. Okay. Now, what about another kind of power of attorney? Well, okay. Oh, and these are questions that kind of come up all the time. People say, well, Carol, what's a durable power of attorney? What does that mean? Well, a durable power of attorney means that it's a power of attorney that stays in effect even if I become incapacitated. Because remember, the principal is authorizing the agent to do things. If the principal is incapacitated, how can they authorize anybody to do something? Well, if it's a durable power of attorney, and that's mostly what we write, if I become unable to make decisions, you have this durable power of attorney, it would stay in effect, and you would still be able to do the things that I've given you authority to do. Okay, and these type of powers of attorney are effective when they're signed. Okay, and we don't necessarily need the agent to do anything right now. The principal can hold on to the power of attorney and say, if I become incapacitated, to go look in my red filing cabinet in my den. That's where I have all my estate planning documents. All right, or you can tell them to call, if you have them with an attorney, call your attorney and the attorney can turn them over. Some people like to prepare what's called a springing power of attorney, which means it springs into effect on the happening of the meeting of the requirements in the document. And it only takes effect when the principal is incapacitated. Now, usually a springing power of attorney will have language in it that says, this document becomes effective if my doctor or if 2 doctors give you a letter that says I'm unable to handle my own affairs. The problem with this, and I don't really like springing powers of attorney for this reason, is that it's hard to get the letters from the doctors. Doctors are busy people and they're like saying, well, I'm very busy and I don't want to give you that. And besides, HIPAA would prevent me from giving that information to you. And that delays the power of attorney going into effect. So meanwhile, you're in the hospital, you need to have your bills paid, you're incapacitated, and the agent is still trying to get the doctor to give them a letter. Assuming you have already signed a HIPAA authorization to allow the medical information, the doctor to release it to the agent, okay, that's a good thing. But then the doctor has to write it, and doctors are doing a lot of other things, and they're not thinking, oh, today I have to go in and write this letter saying that Mary is incapacitated. The other thing I don't like about springing powers of attorney is that once you have that doctor's letter with the power of attorney so that people know that it has sprung into effect, when you go to use it at the bank, you have to show them the medical information along with the power of attorney. If you go to the brokerage company, you have to show it to them. And so now you have now disseminated this medical information out to a lot of other people that really don't need it and shouldn't have it, but that's the only way they'll rely on the power of attorney. I've even had places say, the power of attorney, it's now a year later, and they're like, well, how do we know that Mary is still incapacitated? We want a new letter from the doctor. So it is a way, to, I guess, more limit when the authority would go into effect. But if you trust the agent under the power of attorney, I don't really know that that is the best way to go, simply because of these issues in getting these things to be activated. Okay. All right. Okay. Now, I'm not expecting you to read this slide unless you really sat down and read it, because it's very small type. But Pennsylvania law requires this notice on the front of a financial power of attorney. It could be in the back, but it's supposed to be there. And technically, when you put them with your documents, it's supposed to be all in caps and in bold. But if we tried to do that on this slide, it would never have fit. So we just put it on here so you could see what the language is. And people say to me, Carol, they read these things and they're like, well, Carol, this says that the agent has all this authority. And, you know, I don't know that I don't like this language. Can't we get rid of some of it? No, this language all has to be here because that's what state law requires. So it says here, the law permits, if you choose, to grant broad authority to an agent, including the ability to give away all of your property while you are alive, or to substantially change how your property is distributed at your death, although a power of attorney is not allowed to sign a will for you. Before signing this document, you should seek the advice of an attorney at law to make sure you understand it. So I tell people what I really think, instead of the word notice, it should say warning. It's a warning to you to say, just be aware of what you're signing and make sure this is what you want to do, and that you're giving this authority, which is a very broad authority, to the person that you trust. Okay? Now, not only does the principal have to sign this part of it, the agent also has to sign an acknowledgement. They have to say, yes, I am willing to do this job, and I will keep my assets and the principal's assets separate. I will exercise reasonable caution and prudence. I will keep full and accurate records. So this is, the agent has to be willing to do this. Though you don't just say, okay, I'm naming you as my agent, and not tell them about it and get their permission. Because I had a man, he named his niece, and when we sent out the acknowledgement to her, she sent it back and wrote all over it, no, 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 I refuse to do this job. So we had to redo the power of attorney, and he had to figure out who else to name. So you always want to ask the agent, are they willing to do this? Okay. And you should probably also ask an executor too, because you don't want somebody you've picked and they don't want to do this job. But this is something that they sign, that they have accepted this responsibility. So if they started doing things that weren't appropriate, like they took your money and went to buy themselves a new car, you know, you'd have a way to say, well, you know, you violated this duty to me, this fiduciary obligation that you have to me. Okay. Now, so financial powers of attorney, to revoke them, they have to be revoked in writing if the agent is using the power of attorney to pay bills and things, and you have to notify the financial institutions that you have revoked the power of attorney so that they know to no longer accept signatures from that agent. A healthcare power of attorney, on the other hand, is where you name someone to make medical decisions for you so that they can make sure that you're getting care that you would want, that would help you to, you know, limit your pain, so that they would make sure you would be treated with care, dignity, and respect. The agent under a power of attorney can be authorized treatment. They can withhold treatment or withdraw treatment. And they're going to act on your behalf. They're going to advocate to you. You're in the hospital, and they're going to be the ones who are talking to your doctor. Now, the doctors always want to talk to the patient if they can. But if the patient is unconscious, if the patient is suffering from dementia and they cannot provide information to the doctors, they will then be able to talk to your agent, who hopefully you have talked to ahead of time. I always tell people you want to talk to your healthcare agent. A good time to do this is when you're having a holiday dinner, like the next one will be Labor Day. So when you're having your Labor Day picnic, sit around with your agents and say to them, look, I want to talk to you about what medical care I would want or not want, and what's important to me, and what kind of care I would like. So generally, you're going to give the agent under healthcare power of attorney a lot of authority. And the doctors basically are the people who help these things kind of become effective, because if the doctor can talk to you, they will. If they can't, and you have this power of attorney, they will say, okay, now we can talk to the agent because I can no longer talk to Mary. And usually a healthcare power of attorney will have a HIPAA authorization in it that you will sign as the principal to give the agent authority to get medical information. Okay. All right. Now, often with a healthcare power of attorney, where you're appointing someone to help you with medical decisions, you'll do a healthcare advance directive or a living will. And this is the document that tells the hospital, your doctors, your family members, what medical care you would or would not want in the event of an end-stage medical condition, if you were in a persistent vegetative state like a coma, if you were suffering from severe brain damage, somebody hit you in the head, or severe brain disease, you have advanced Alzheimer's disease, and it says to them what medical care you would or would not want under those circumstances. So it's written instructions expressing your wishes for medical treatment. It will also deal with organ and tissue donations, whether you would want to allow that or not. And in Pennsylvania at the present time, there's actually two types of organ donation that you can authorize in a healthcare directive. The first one is the donation of traditional organs, heart, lung, liver, kidneys, corneas, those type of things. But Pennsylvania also allows the donation of what are called vascularized composite allografts. So you can decide to allow the donation of your hands, your facial tissue, or your feet, because they can transplant them. So you can decide, I'm going to donate anything and everything, I'm going to donate nothing, or I'm willing to donate organs, but I'm not willing to donate vascularized composite allografts. So it's just something to be aware of. And as this says here, the doctor has to say that you're in the condition where this document would be read and listened to. So if you went into the hospital for surgery, they were going to remove something from your leg, and they're operating on you. You walked into the hospital, and while you're on the table, you have a heart attack. They're not going to care that you have a healthcare living will, because they're going to do whatever they can to bring you back. If they then determine sometime thereafter, much later, that your brain was deprived of oxygen when you were having the heart attack, and now you're in this persistent vegetative state, now they would look at your living will to see what you would want us to do under those circumstances. Okay? All right. Now, living wills come in many different forms. This is one form. If you went to UPMC, they might use a different form. They might use the 5 wishes form. There are different religions have different forms of living wills because they're willing to allow or not allow certain things. So you can get one from the Catholic Church. You could get one for Orthodox Jews, for example. But there are different religious entities that have different language. So again, this is something that should be signed. It should be witnessed and notarized, not required for a healthcare power of attorney and advance directive. But it's not a bad thing. It basically just helps to be sure then that you've actually signed it. Okay, now this is one we don't always hear about, but it is important for many people. It's a mental health care declaration and power of attorney. And for people who unfortunately are diagnosed with certain mental illnesses, they may need help in making decisions. And unfortunately, a general health care power of attorney will not allow that. They don't deal with mental health decisions. So in this, it's a set of written instructions. You get to express what your preferences are for mental health care treatments, medications, experimental treatments. Would you want to have electroconvulsive therapy? Where might you want to go, or where might you not want to go? You might say, well, I would go to Western Psych, but I don't want to go to Mercy Mercy Health. It's different because it specifies when it becomes effective and when it terminates. And it is usually good for no more than 2 years. So a mental health care power of attorney and declaration has to be something that's re-executed regularly. If you're having an episode of mental health problems, when it's going to expire, they will keep it in effect until you are better. But other than that, they do expire. And it is specific as to what powers you want to give to the mental health care agent. But these can be very helpful for people who know they have a history of mental illness and they want to be able to have someone help them with decisions under those circumstances. Okay. Okay, so this is a HIPAA authorization. This does not allow anybody to make decisions. It basically only allows someone access to medical information. And you can sign a HIPAA authorization at your doctor's office. You can specify in there if there are people that you'd want medical information released to, if there are people you don't want medical information released to. So you have 4 children and you have 1 child perhaps who has their own mental health issues, and you know that, you know, they're trying to run your life. They can't even run their own life. And you might say, I don't want to have my medical information released to that child. So it's a very useful thing. Now, this is a cute little advanced healthcare directive notification. It's a card that can be carried in your wallet, indicating that you have a healthcare power of attorney and living will, and it names the agent and the alternate agent and phone numbers. So this is a good thing to have so that then they can be reached in case of a medical emergency. But generally, it's going to take a little bit of time for that to happen. Remember, if something happened, if you were walking down the street and you suddenly collapsed, an ambulance is called. Their job is to get you to the hospital alive, and then what happens in the hospital will be different things depending on, but this can be a helpful thing to have. People say, well, Carol, where should you put your healthcare power of attorney and advance directive? Some people, they might leave it in an envelope, a big brown envelope or something in their front hall. And it says, if anybody takes me to the hospital, grab this and take it with you. Some people put it in a tube in their freezer because they've been told that that's a good place to leave it as well. You want to make sure that your family knows that you have it. Again, it's not going to do anybody any good if you don't. Okay? All right. Let's see. So we've listed here some resources. So the first one at the top here, this is the Allegheny County Bar Association. The Medical Society and the Bar Association worked together to develop a power of attorney and living will form. They all felt was a good form. It's free to download, and it can be very helpful. It has directions with it to tell you, answers questions. We've also got ones here from the University of Pennsylvania Educational Pastoral Department. That's another advanced directive. There's another Catholic organization here as well. And this is something from UPMC. So as I say, there's a lot of resources out there, and most people don't have these. It's very hard to sit down and really think about what medical care you would or would not want at the end of life. It's different if you're looking at this and you're in your 20s, if you're in your 50s, if you're in your 90s, okay? You may want very different things to be done depending on what stage of life you're in, or you might want different decisions if you have a diagnosis of some kind of very debilitating disease that there's certain things you do or do not want. And so that's why it's important to sit and do these things while you're able to. Because here's what happens. If you haven't made these decisions and something happens to you, your family might have to go to court and pursue a guardianship. A guardianship is when you declare a person incapacitated. We have guardian of the person to make medical decisions. We have a guardian of the estate to make financial decisions. And this is all done by a judge who doesn't know you, who doesn't know what you would prefer, but somebody has to be able to make these decisions. And that's what the court is for. Guardianships, once they're in place, you then have to go back to court if a person regains their capacity to terminate it. So I tell people, you really don't want some strange judge making those decisions for you. And again, sometimes the judge appoints somebody that you would not want to appoint because that's the person who showed up in court and asked for a guardian to be appointed. And you're in this hospital and somebody needs to make these decisions. You can have an emergency guardianship. You've collapsed on the street and somebody has to be able to do things. You can have a permanent guardian. That's then for the rest of your life. Okay, now here's some other resources about death and dying, for palliative care, serious illnesses. The Conversation Project. Have you had the conversation? I will tell you that I frequently tell people they should have these discussions with their families. And I usually get the children say, well, we don't want to talk about it. And the parent doesn't want to talk about it. And they're trying to force this conversation. It's better if you can just say, all right, I'm going to listen to this. We can spend 10, 15 minutes. Let's have the discussion, because then you'll at least know, and your parent might know what your views are, because a parent might say, look, if I have an end-stage medical condition and I'm dying, it's not a question of if, it's a question of when, because they've done everything they can. I don't want you to prolong the process of dying. I want you to let me go. And if your child says to you, I don't care what you're saying, I would do everything possible to keep you alive as long as possible, that's probably not the best person to name as your agent in that healthcare power of attorney, because they're not going to carry out what you would want. So that's why the conversation is good. All right, I had a woman, she wanted to name her daughter the nurse as her healthcare agent and her son the accountant as the financial person. And her daughter said, oh no, I don't want to make those decisions. I will not. So her son got both jobs. All right, and then this is an interesting what matters to me workbook, because these are things that can be really helpful. We've also put a resource on here about if you suspect elder abuse. There's a statewide elder abuse hotline. You can call the Allegheny County Department of Aging. They have adult protective services that can help an older person if they are being abused. And these are really important things to know because unfortunately, Allegheny County has the second largest elderly population in the country next to Dade County, Florida. And so we have a lot of people here, and there is unfortunately a lot of people who want to try to take advantage of people. All right, do we have any questions? If not, I'll make stuff up. So no, but I mean, so well, I see people in the room here. So how many of you have your wills? Yes, okay. So see, people that don't, they should have them prepared, okay? I'll tell you the most popular time people want to do wills. They want to do them when they're going on vacation. Why? Well, I'm going on a plane, and what if the plane crashes and I think I better write a will, okay? And sometimes that can be hard to do as a lawyer at the last minute, so we tell people about holographic wills. Or it's the Titanic scenario. The whole family's going off on a Caribbean cruise, and what if there's a huge iceberg and the ship goes down? So you can do it then, but it's also good to do it ahead of time, okay? People always say, well, Carol, I'm not going to do my power of attorney until I need it. Well, the problem is by the time you need it, you might not have the capacity to do it. So, you know, it's a good idea to do ahead of time. When my children turned 18, I had them both do powers of attorney so that I said, just in case anything happens, I can make medical and financial decisions for you. So, which was, it was good. It was a good thing to do just to be on the safe side. So if you have children or grandchildren who are adults, means they're over the age of 18 and they're going off to college, having these powers of attorney could be very useful. I had a parent, her son was at school in Michigan and she got a call from the school, your son is in the hospital. What's wrong? We can't tell you. HIPAA. Under the privacy laws, we can't tell you what has happened. Luckily, we had done a power of attorney. We faxed it up there, and her son was in a coma. It turned out he had diabetes and didn't know it. He was fine, but not at that time. But she was able to get the medical information. She still had to, you know, was able to get his records and still drove up there to deal with the situation. But as a college freshman, he had not been living, shall we say, the best life, and you know, sort of did this to himself. But it worked out okay. But I think of it, what if it was a situation where there was a school shooting and you didn't have any way to know why your child's in the hospital? You know, did they fall? Were they shot? They won't tell you because of HIPAA. So this can be a really useful thing. So we should have these documents for ourselves. Our children, once they're 18, should have them. Our parents should have them, or grandparents, depending on your age and the age of the people in your lives. But it's just better for people to make these decisions. Okay. Any of you have powers of attorney? No, okay, you do. Oh, you are power of attorney. Well, that's a good thing. Okay, so if have you heard to do any jobs as the power of attorney yet? Okay, good. That's good. That's very much appreciated. And you know, family members really appreciate it when somebody steps up because sometimes that's really hard to do. But it's, as they say, it's still good since I know you're both over 18. Everybody here is over 18. It's just helpful to do. It really is. It's not that expensive. I will tell you this, doing powers of attorney is usually hundreds of dollars. Guardianships are thousands of dollars. So if you can avoid going to court and having to have all that money spent, it's a much better use of your assets. Trying to think. So, oh, I know. So in Pennsylvania, we still have inheritance taxes, which I've talked about before. So even if you have a will or if you pass assets through to people by beneficiary designation or joint ownership, they still will have to pay Pennsylvania inheritance taxes. Between spouses, the tax rate is 0. For lineal descendants, parents, children, anybody in that line, grandchildren, it's a 4.5% tax. A couple of years ago, the legislature passed a law that if you leave things to your children and they're under 21, they don't have any inheritance tax, which is a nice thing for minor children. To siblings, your brothers, your sisters, if you like them and leave something to them, it's a 12% tax. And for anybody else, it's a 15% tax. If you leave money to charities, there's no tax on that. That helps reduce your taxes, actually. But it's, it's just kind of good to know when you're making an estate plan, what might the issues be with inheritance taxes if you're going to try to do this yourselves, okay? Once you've prepared these documents, you want to keep them somewhere safe. So you either might want to put them in a fireproof box at home, you might want to put them in a safe deposit box, because you don't want to just leave them laying around, where if your grandchild shows up and says, oh, look, paper, and they take out a crayon and start writing all over your will or your powers of attorney, which has happened, that could affect whether they will be effective, because the person looking at it later after you're gone doesn't know if you were the one that wrote on it with a crayon, or it was somebody else. So if you crossed off like one paragraph, they don't know, who did that. So that could cause a problem with what your plan is. Okay. All right. And again, make sure the people know where these things are so that they can find them if something happens to you. Okay. All right. Okay. Well, thank you. It's been very nice.